This is AHA Business Radio, creating aha moments for business, by business, and about business, providing opportunities to discover information to help you run your business and guide your decision making. The more you know, the better decisions you make. Now, here's your host for AHA Business Radio, Alan Hirsch.
One of the things that you taught me at very early when we had the problems, and fortunately I had another general counsel who advised me when we first started having some problems to reach out to a bankruptcy attorney, if nothing more than advice and options of what options you have as a business owner, because bankruptcy can be a strategy through a Chapter 11 if it's properly handled to help a company through very difficult times.
That's correct. And the key is to identify the problems sooner rather than later and to address those problems. Because I find that in a lot of circumstances, the business owner has unrealistic expectations about the future. And so they kind of procrastinate, and as the company slides down and the assets kind of implode, it makes it much more difficult for bankruptcy Chapter 11 proceedings to assist that business enterprise.
Yeah, but there's now, and I want to take it a little bit different, predominantly because most of the listeners and most of the people in Baltimore operate small, mid-sized businesses.
Right.
So there's a special category, as I understand it, for small business bankruptcy.
That's correct. In a Chapter 11, if your debts, both secured and unsecured, are less than just a tad under $2.5 million, then you are then subject to the small business provisions of the Chapter 11. And that Chapter 11 small business is designed to streamline and get a company out of bankruptcy sooner rather than later.
I want to turn the tables because far more companies will have a customer go into bankruptcy than who will ever go into a Chapter 11 or even a Chapter 7 themselves. So what are the rights and what should, if I have a company, what should I do and what are my rights if someone that owes me money files a bankruptcy, Chapter 11, for example? What are my rights? What should I do?
Well, I'm going to assume that that's going to be an unsecured claim, that you don't have any collateral
Correct.
backing up that. The first thing that I would do is file a proof of claim. When you get notice of the bankruptcy from the bankruptcy court, they will have a proof of claim attached to it in a Chapter 11 proceeding. I would always recommend to my clients to file that proof of claim. Now, under the statute, so long as you're listed in the bankruptcy schedules as non-contingent disputed, then that amount of money is allowed. But you don't know whether or not that how that bankruptcy attorney is scheduling you. So as an ounce of precaution, if you file that proof of claim, it supersedes anything that the debtor can do, and it provides a basis upon which to have your claim allowed. Because if your claim is not allowed, you don't participate in any distributions that ultimately will come about in a confirmed plan of reorganization.
So if someone files a bankruptcy, they usually have a list of debtors that are listed with how much they owe money to. Creditors, how much money they owe each one of those.
Correct.
And that report will go out to...
No, you'll never see that. It's part of the bankruptcy process. You would have to go to court in order to review those schedules.
So you really don't know whether you're on that list or not. So to protect yourself,
right,
you're suggesting that if you know of one of your customers files a bankruptcy, you should immediately go wherever you need to go and file a claim of what you claim they owe you.
Absolutely, because even if you're not listed but you have knowledge of the bankruptcy proceedings, you will be bound by the outcome of the bankruptcy proceeding. The other interesting thing is that recently, again, the statute was amended, and if you are a vendor and you have supplied goods to the debtor in the ordinary course of business within 20 days, then you can file your claim as a priority claim, which now gives you additional rights and a better prospect of getting paid in a bankruptcy proceeding. Anything beyond that 20-day period, later than 20 days, you're an unsecured claim and you're low on the totem pole.